That's right, John. Good to see you again. Good to be back as always. Love coming on your show. I think you must be talking about Munoz v. Department of State,
Oh
which
yeah, exactly. Where they called into question consular non-reviewability or something like that.
called into question, is to say it lightly. They blew it up in a very narrow circumstance. And I said it on my podcast that my tweet on this case went viral. My wife was very quick to say that you're not viral if you only get 100 likes, but I think it's viral.
100 likes,
I
that's huge for immigration. Yeah.
I think I went viral on Twitter, Elon Musk's Twitter. Munoz v. Department of State. I mean, it's outrageously complicated. The doctrine of consular non-reviewability essentially says that the Department of State can deny visas no matter what without even really explaining themselves. And that's on Kerry v. Din and all of those cases. Munoz v. Department of State, before I get to the holding, though, it has a lot of interesting stuff in it. First of all, the Ninth Circuit is relying on concurrences from Justice Kennedy. The only reason you can even get in the door, it's possible that Mr. Munoz, who's a non-citizen abroad, doesn't even have standing to challenge it. It's possible. But Miss Munoz, his wife, a U.S. citizen, does. And it's interesting, man. It's based primarily on Justice Kennedy, who's no longer there, the fundamental right to marriage, and there's a fundamental right to live with one's spouse, or at least a constitutionally protected one. And so those two fundamental rights, according to the Ninth Circuit and Justice Kennedy, are in tension. That fundamental right to marry from Obergefell, the same-sex marriage cases. And so, as an aside, if the Obergefell line of cases falls after the abortion stuff and the current Supreme Court wanting to blow up Justice Kennedy's legacy on fundamental rights, then we have a very possible different consular non-reviewability jurisprudence. Maybe you can't sue at all because there is no constitutional rights, but as I did in my podcast, I digress. Currently, there is a fundamental right to marriage and to live with your spouse. And so how do you infringe on that? And with the doctrine of consular non-reviewability, one of the main ways to get around the doctrine is to show bad faith. That's one of the main, and it's almost impossible, right? Because you've got a consulate officer abroad, and how do you show what? Like that the consulate officer is racist, that they just don't like you because you used to date their brother? I mean, God knows what is bad faith? How do you even show it? And you need discovery, but the doctrine of consular non-reviewability blocks discovery in federal court too. I mean, the whole thing is crazy. And so this case says, if the Department of State doesn't timely tell you why they're denying the visa, then the doctrine doesn't apply, even if they tell you later. What is timely? I don't know. But like in this case, the Department of State kept letting it seep out over many months and eventually years after federal lawsuit, that eventually they made it very clear Mr. Munoz's tattoos, and some Department of State guy from El Salvador or some contractor said he's MS-13. Like that all came out eventually, but it wasn't timely. And so even though it came out eventually, the doctrine didn't apply. And if the doctrine didn't apply, well, you've just got a regular federal lawsuit against the Department of State, where it might be before a federal judge whether or not it was appropriate for them to find him MS-13. Now, there's a lot of qualifications. The ground of inadmissibility they were alleging he fell under was just the general criminal conduct one, and that one might have additional requirements. So it does get a bit, it is a bit specific, but it is it's a big chunk into the consular non-reviewability doctrine. The counter is that all they have to do is provide basic notice of the reasons they're denying in the future, and they get around this decision. Plus the Ninth might go en banc, but we have so little to challenge the consular non-reviewability doctrine that something like this becomes a big deal.
But just getting them to give that from the DOS standpoint is a lot, because from the case I've seen, I never had to deny case myself, but what I've seen, they don't tell you anything. Just send the case back. And you're emailing them, they're like, "Well, we sent the case back." And I'm like, "Well, why?" Then you wait
for revoking the I-130.
Yeah, revoking I-130. Yeah. So this will force them to do something, but then again, they could probably just say, "We didn't believe it's real." And then what are you going to do? How specific do they need to be in their explanation? But at least it's something.
Yeah, I mean, that you're taking the counter, rightfully so, the counter argument that many people in the Twitter feed then took, like, oh, they don't have to do anything. Oh, they can just go en banc in the Ninth Circuit. Maybe so, but I mean, look, like when you're drowning, you take the worst life raft you can get, right?
Yeah.
I mean, there is nothing. We had nothing for consular non-reviewability. Now you have something in the Ninth, and that's what we do, right? How far does this decision go? How much notice is proper? Right now, we've got a decision. I know that there are advocates who reached out to me after, who are in federal court all the time, who are already asserting this. So there will be many Munozes going forward.
Yeah.
And we'll see what happens with the case, but it's a fun case. It's an interesting case. It's good stuff.
Yeah, I mean, this is really positive. At least, just chip at this non-reviewability stuff's really important because it's just out of control. Cool. I'm glad I didn't read the case. I just read the headlines, so I'm glad to get some more info on it. Bye-bye.